नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
So that means we're not referring to clause 13, we're referring to the paragraph after that, right?
Or section 57 itself, right?
Yes. So I got
right. So this is right after.
I got it.
I'm very sorry. I'm very bad with these numbers. Even generally, I'm bad at numbers.
Yeah. Also, sir, we studied it as a part of evidence when we studied this. Then, when we referred to section 45, where we just started, opinion of experts. Now, where we also analyzed certain cases wherein we decided that this cannot be the sole basis of conviction by any code of law, opinion of experts. This always needs some kind of corroboration. So that corroboration needs to be some document. So is it that the other sources that you refer to, like section 38, section 78, section 84, all these sources, which are documented sources, they can be the sole basis of decision or conviction, whereas opinion of experts needs corroboration? I mean, if we could have some light on this also, that would be...
Well, that's an interesting point. So generally, yesterday I was trying to read something on it and how private international law has actually reflected on the question of expert evidence. Now, when we are talking about expert evidence, the idea of expert evidence also has to be seen in the light of this another criteria, to the satisfaction of the court. So if the court is not satisfied just with expert evidence, and generally it does not happen, when an expert evidence is given, in addition to it, certain documents will also be presented by the party at hand. It will say that, fine, I mean, in addition to these laws which are there, because if the laws are codified, if it is part of a judgment, or for example, it is part of a legislation, in that particular sense, it becomes easier for the parties to maybe present the document and to corroborate it, to be sure about it, to understand its exact implication in the case at hand. Court can invite expert evidence and ask them to reflect on that. But whatever court does, the chief criteria or the principal criteria is that court has to be satisfied about it. The court has to satisfy itself about the foreign law. Yes, this is the foreign law at hand, and this is what we are supposed to invoke to decide the case at hand. It is reflected, this idea of satisfaction of the court is reflected in the phrase, when the court has to form an opinion. Now that is an important part. To what extent an expert opinion is able to contribute to this idea of form and opinion. So at least in terms of how the practice of private international law is placed, it's the multiplicity of documents which comes before the court. Expert evidence could be one, maybe a very significant factor, maybe the most important part. It might appear as the only important part, but it often comes with other aspects as well in terms of maybe some papers, some case law, some practice, some legislation being presented before the court, satisfying the court about the proof of foreign law. That is what I want to say, that expert evidence need not be read in isolation with the other criteria which we have identified to the satisfaction of the court. I hope that's fine.
Thank you, sir. Yeah, that's great.
Yeah. Now, very briefly, I'm going to reflect on exclusion of foreign law. Very briefly, and we will be touching on exclusion of foreign law regularly throughout our discussion this semester. With every case, you'll find one or the other reflection on this issue of exclusion of foreign law. Cheshire puts it in one way. In fact, I was a bit worried that I have to just cover this particular aspect as briefly as possible, and how should I really reflect on this? I think Cheshire really helped me when he said that circumstances might arise, and I'm just trying to paraphrase him here, that circumstances might arise or occasionally arise in which law of the forum must be preferred to the foreign law that would normally be applicable to the case. Now here, Cheshire is trying to put two system of laws in opposition to each other. One is lex fori and another is the foreign law to be applied in that case. Now imagine every process is done. Every single process is done. Jurisdiction is established. classification has been done, incidental question has been solved, if at all there are any incidental question, renvoi or no renvoi, private international law rules have been invoked to see what is the foreign law. Specific law has also been identified that, okay, it looks like that the law of, say, that a very specific legislation of Brazil would apply, for example. And within this specific legislation, a particular provision in Brazil, a particular provision of that particular statute would apply in the case at hand. If everything is done, can there be a situation which can exclude the application of foreign law? Can there be a situation where court says that no, we are not going to apply this particular foreign law, even at the last stage, itni mehnat karne ke baad? Now, the general position, and this seems to be the general position throughout, that courts have shown liberal attitude towards exclusion of foreign law. That they generally don't exclude foreign law. And in that regard, the word which is invoked by at least two different scholars is that courts have taken a cosmopolitan approach when it comes to the exclusion of foreign law. They generally don't exclude the application of foreign law in such a situation. But when I say they generally don't do it, it means that there might be certain exceptions. Now, it is these exceptions that we are going to reflect on. The first is public policy. If a foreign law is against public policy, it is excluded. And if you ask me to define public policy, I don't have a definition. I don't think anybody has a definition. And therefore, it is wonderfully put in a judgment that we cannot define public policy. We can only exemplify it. We cannot define public policy, but we can only illustrate it. Because any definition of public policy would leave something out or maybe include too many things. So the idea of public policy has to be understood in more of a contextual sense when the situation arises. Of course, there could be exemplifications of public policy in different laws, in different provisions, in say common law practice as well. The second ground of exclusion is penal law. Yesterday there was a question in this regard. I don't know, in one of the sections. Penal laws are excluded. Foreign revenue laws are excluded. And foreign public laws are excluded. These are some of the laws, or these are some of the grounds on which foreign law is excluded from application. This is it for now. We are going to come to some of the
foreign public laws.
Yeah, foreign public law. I mean, since we are dealing with private law necessarily, so foreign public law generally is excluded. As I said,
so how do you penal laws with public laws? Isn't it the same thing or is it different?
No, we can consider it as same thing, but when you look at, for example, Cheshire or, for example, Govindraj, they try to make it more concrete by saying that within public laws, they talk about laws relating to expropriation of property, for example. That's an example which has been given. So there is no fundamental distinction. Public law is a broader category in which your revenue laws and penal laws might fall part of. But they are trying to be more specific by identifying penal laws separately, revenue laws separately. Because in terms of penal laws and revenue laws, the enforcement jurisdiction is considered in a very strict sense. And that's one of the reasons often scholars try to put them differently, merely for the question of asserting enforcement jurisdiction. There's a much more concise or much more precise form of enforcement jurisdiction which is in relation to penal laws.
All right, so thank you, sir. Sir, also, when we discussed in one of a few initial lectures, isn't Committee of Nations also a factor determining the decision on exclusion of foreign law?
A Committee of Nations is a basis. There's a difference. Exclusion of foreign law and basis of private international law are two different things. Committee of Nations rather furthers that particular agenda of application of foreign law. Here we are more concerned about exclusion. There is an interface. There is a very natural interface between the two. But Committee of Nations is fundamentally considered as the basis of private international law. As to why should a country apply foreign law in a matter which is before it? I mean, why should an Indian court be worried about foreign law? Why should an Indian court be worried about law in Ghana, Kenya? And the explanation which is presented are multiple. And one of the most significant explanation, of course, which is which is also criticized, including by Cheshire himself, is that it is not a very profound basis of private international law. Be that as it may, Comity of Nations is considered as one of the bases as to why courts invoke foreign law. Basis. It's rational behind invoking foreign law to decide the matter at hand, and how it goes further and talks about the fact that it might also change the rights and obligations of parties if we don't really take into consideration foreign law in a dispute where foreign element is involved. Or, for example, it might lead to a situation where party have different legal status in different jurisdictions, if at all we mechanically apply the internal law of a country. So all these things are considered as the basis of private international law. Here we are trying to be much more specific. Here we are trying to talk about grounds of exclusion of foreign law. Manu, is it better?
Yes, it's much better. So what I was referring to, in fact, more specifically is the concept of principle of reciprocity that we discussed. And, if the foreign country whose law we are here to apply is not recognizing our law deliberately, one is that case. And the other case, what we discussed is like in the case of laws of alien countries, enemy countries in times of war. So those are also could be considerations for exclusion of foreign law, or
when it comes to alien enemies, the matter might be stopped at the level of jurisdiction itself. So the matter might not proceed beyond jurisdiction.
Not alien enemies. The law of the foreign land, what we are the lex causae that we have identified, that is in a state of war with India. So could that be a basis of exclusion of foreign law? Even if we are not dealing with an alien enemy, we are dealing with an Indian national, or maybe whoever we're dealing with, that's not relevant here to the context.
All right. So it's that whether if India is at war with another country, whether the laws of that particular country would at least, I don't see a problem in terms of applying the foreign law. And the other aspect, applying the foreign law of a country which is at war with India, and not deciding a question relating to rights and obligations of alien enemies. So at least I don't see a problem. Indian courts would apply. And if in one of the cases, if you remember, that is precisely what happened, where when the case was filed, the person was not an alien enemy, and court reflected on that aspect, that what matters is that on the day the person was not an alien enemy, and subsequently the person, even if the person has become an alien enemy, the suit will continue and it won't bar that particular individual. Applying the analogy to the question which we have posed, I don't think the foreign law would not apply, the foreign law of a country which is alien enemy, to decide the right and obligations of individuals who are not alien enemy per se. So I think court would generally take that factor into consideration. That's point number one. Similarly, the second point, that the laws are not being recognized. But how does that recognition really works? Because states don't formally recognize the laws of another country. So generally it does not happen that court would or for example, one country will or will not recognize the laws of another country. There is something called recognition of state per se, that you don't recognize that particular state as a whole. But recognition of laws, when it comes to recognition of laws, we are less concerned about the public laws. We are more concerned about, say, those laws which deal with the private matters of individuals, say that how one individual interacts with other individual in matrimonial sense, in contractual sense, or for example in terms of a property exchange. Similarly, with regard to, say, tortious matter that we are really concerned with when we talk of private international law. So that should not be a restraint. The question of recognition, however, becomes extremely central when it comes to recognition and enforcement of foreign judgments. At that point of time, the question would become very, very important. Now, a court might not recognize the foreign law based on one of these factors while applying it to a dispute at hand. So, public policy. So, if the law of an alien enemy country, or an enemy country rather, the law of an enemy country is against the public policy of India. Or, for example, it is a penal law, or it is a revenue law, or, for example, it is a foreign, or it is a public law of that particular country, then those laws are excluded. Now, it can be a ground to exclude the laws of enemy country if it fits within one of these exclusionary criteria. That is, it is against public policy. Now, you might argue that it is against public policy. But per se, at least my preliminary view is that no, it will not be excluded just because it is an enemy country. And that too in order to decide a private matter between individuals who are not even alien enemy. So the individuals are not even alien enemy in terms of how it splits. That's one. One needs to make a distinction between exclusion of foreign law and also recognition and enforcement of foreign judgments. These are two different things. Exclusion of foreign law might happen at the level of applying the law. But once the judgment has been pronounced, and if the judgment has to be recognized and enforced in another jurisdiction, that is a different question altogether. The grounds for not recognizing and not enforcing a foreign judgment are different. That is provided in the CPC. There is a very specific provision for that. Ideally, we should have ended this entire module with a discussion on enforcement and recognition of foreign judgments. But we are not doing it because a full-fledged module is there in your syllabus to deal with recognition and enforcement of foreign judgments. Otherwise, we have followed the trajectory of jurisdiction, applicable law, and the last part which I'm talking about, that is the recognition and enforcement of foreign judgments and courts. That's a complete one module which is there in your case, in your syllabus. Yes, I hope that part is clear, at least better, if not clear.
Yes, so much better. So I was basically referring to like cases like Philippines or Venezuela, or nations like very extreme nations where there either has been a genocide or there has been a coup in a very random and ruthless manner, and someone has come to power, and the whole international community is in boycott of that particular nation. Still, we would recognize the laws of that country for the purpose of private international law. That was
Okay. Yeah, that's a good question, Manu. Now, unless those laws are, and if those laws are against public policy, exclude them. Now, what are we actually worried about? We are less worried about the nature of the country as such, extreme or no extreme. Now, my idea of extreme seems to be significantly different from your idea of extreme. I mean, I'm unable to confine the notion of extremism to few nations. Of course, Philippines seems with Duterte. There's some very interesting personal experiences to share, but maybe some other time regarding Philippines. Or, for example, other countries as well, in terms of how the regime per se is very extreme. Now, if we take that factor into consideration, we are mostly getting into the issue of recognition of government and recognition of state. Here we are more worried about deciding on the question of private rights and obligations of individuals. Now, it is this aspect which differentiates public international law from private international law. And that because of this precise distinction, we should not conflate these ideas. At least that is my preliminary observation. For me, if at all one has a problem with the law of the foreign country, it has to be brought within one of these list of exclusions. Public policy itself is a very, very big category. Now, if the laws of the other country are so brutal, are so bad, that an Indian court believes that no, such a law is against the public policy of our country, excluded. That is precisely what that we are referring to. But I doubt that the political status or the nature of the political regime in a particular country would be a deciding factor to rule on private rights and obligations of the parties before a court. And that seems to be that is my preliminary observation in this regard. It is an important question. I'm not trying to demean that question. That is a very, very important question, but mostly related to public international law, recognition of government.
It's quite clear now, sir. Thank you so much.
Okay. Thank you for all these questions. Any other question here? Anything, something which I missed? Let me check the chat box. Seems clean. Manvi had a question. I'm sorry. Manvi had a question. I pasted that particular question somewhere. Yes, yeah. How does the court apply the doctrine of renvoi when the party is not able to prove the foreign law and the court presumes that the foreign law is the same as lex fori? Does it apply the doctrine at all? Okay. How does court apply the doctrine of renvoi when the party is not able to prove foreign law and court presumes that the foreign law is the same as lex fori? Oh, Manvi, that's a good question. I think Manvi is here, right? I saw her in the chat box somewhere. Yeah, she's here. Oh, all right. Now, Manvi, when we are referring to renvoi, we are talking about different steps of a private international dispute. It starts with jurisdiction. It goes to within the process of identification of applicable law. That's the second step. What we do is that we identify different steps even within the second broader stage, that is of identification of applicable. So we first classify the issue. If there are incidental questions, we take care of that. Then we look at our own private international law rules to see which law would apply or law. Namaskar. COVID. Because here we are just trying to identify which body of law would apply to the dispute at hand, whether it would be a French law or whether it would be, say, British law, whether it would be Spanish law, whether it would be Indian law. So here we are just trying to identify the body of law. And once we have identified that, yes, it is going to be French law and Indian law, then comes the question of proof of that particular law. So renvoi, at least in a theoretical sense, precedes the question of proof of foreign law. That would be my response. So once it precedes the question of proof of foreign law, in such a situation, in such a situation, of course, application of renvoi to the issue of proof of foreign law is difficult to be conceived, to put it in general sense. Is that clear, Manvi, or do I need to explain it differently now?
So to what extent is the question relevant for the courts of India, since they, do they observe renvoi?
In India, we don't have it. So in India, that's something which we have, at least I've made sure, deliberately I've made sure that I repeat that point multiple times so that you don't get confused. In India, courts have not recognized doctrine of renvoi. But I'm sure her question is relevant even generally, for example, to say courts which adopt the policy of doctrine of renvoi for that matter. Thank you, Manvi. It seems that it is clear. All right. Now, this takes me to the next aspect. So in whatever time we have, maybe 15-20 minutes might be remaining, what we might do is to get into domicile. My God, I was waiting for this module to come. Not for any other reason, not because I'm fond of it, but too many questions about domicile. And I was skipping those questions because there's a specific module on domicile. And some of you might be thinking that why is he doing it deliberately, not answering all those questions on domicile? No, there was a very specific reason as to why I did not talk about domicile initially, so that you don't get confused. Domicile is a concept in itself. It will take time to understand domicile and read cases and domicile of origin, domicile of choice, domicile in relation to colonial experiences. It's going to be a very, very fascinating area. In fact, I never took private international law seriously before I joined Delhi University. And I joined Delhi University only as a teacher. I did not study at Delhi University. And two areas while teaching private international law which attracted me the most was when I taught this paper last time, I thought it was domicile. And given a chance, whenever my time permits, I would like to work on first domicile and second alien, the question of alien enemy. And thanks to the question from the students, it was only because of these questions that I was really able to go back and reflect on it, because the general literature on these aspects, it's hardly anything. You will not find anything in the secondary literature unless you go and read about it, say, just randomly cite randomly type it in Manupatra, alien enemy, or domicile colonialism. You'll find some interesting cases which has not been worked upon. And I would like to come back to these two issues whenever my life permits me to go back to. And maybe if one of you are in a position to help me out with it, maybe assist me with my work, I would be more than happy to. Whenever I do that, I'm at least too occupied with lectures at this point of time. I'm not able to think on these lines. But domicile is a fascinating area of study. It's a wonderful area of study. Extremely problematic, extremely problematic the way it is conceived. We are going to talk about domicile for the next 1 week or so. And in so doing, what we are going to reflect on is also the difference between domicile, nationality, and habitual residence. So these are the three different ideas. Of course, we would be spending more time on the idea of domicile because that seems to be the crux of the entire issue. Because nationality and habitual residence are relatively easier to understand. And we will try to see, and here comes the cases. Private international law is all about cases, or is mostly about cases. I should not say it's all about cases, mostly about cases. And for the first time, our fascination of reading cases at Delhi University will be reinforced here, that we will go back to the case laws. We'll read many case laws when it comes to domicile and how the concept of domicile has been applied by the court. Fine. So it's already 12:30. Since I thought that we still have 5 to 10 minutes. Fine. Let's not get confused with different things which we are trying to do. Let's meet tomorrow as planned, and let's start our discussion with the idea of domicile. We will try to reflect on what is domicile, what are different kinds of domicile, and how domicile has been invoked by courts in different jurisdictions. We will try to do it over the next 1 week or so, finishing the entire module. Is that fine? Any issues with regard to domicile? We just have 5. I'm sorry. I presume that we have 10 to 15 minutes. And I'm very bad with time. Even with the other lecture, I exceeded time for 5-10 minutes and realized only when students started dropping messages. This is something which I wanted to request. Can one of you remind me at say 11:25 or whatever 25 that might be, 9:25, 10:25? That is 5 minutes. And 5 minutes before our lecture is supposed to end. Can you just remind me? That would be easier for all of us.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।